Welcome to the podcast, To Preserve, Protect, and Defend the Soul of America. The topic we shall discuss in today's show, the broken bench. America's Supreme Court in the age of manufactured majorities, ethical collapse, and democratic legitimacy crisis.
Yeah.
Hi, everyone. I'm Sam, and I'll be your guide today as we navigate this incredibly complex landscape.
And I'm Alex. I am going to be here to help break down all the history, the data, and, the structural mechanics behind what we are looking at in the source material today.
So to start us off, I want you to imagine playing in the Super Bowl. The stakes are literally as high as they could possibly get.
Right.
But right before kickoff, you look over and realize the referees are actually wearing the opposing team's jerseys under their uniforms.
That is quite the image.
Right. And the question is, do you keep playing? Because if you look at the mountain of data we are doing a deep dive into today, that is precisely how a massive portion of the American public is starting to view the highest court in the land.
Yeah, the game is still being played, but that fundamental belief in the referees is it's vanishing.
Exactly. And the source material we are analyzing today, it doesn't just treat this as some bad news cycle or, regular partisan bickering.
No, not at all. It maps out a multi-layered legitimacy crisis. And our mission for this deep dive is to unpack this crisis by breaking it down into 5 distinct components.
Right. So we're going to look at the structural flaws, the episodic breaking of norms, the ethics void,
the doctrinal shifts against public consensus, and finally, some perspective reforms. We are really exploring what happens when the people who are governed by the law fundamentally stop believing in the institution that's handing it down.
It's a huge topic. So let's start with the warning lights flashing on the dashboard, so to speak. The data pulled for this first section is pretty jarring.
It really is.
Because we aren't talking about a slow generational decline in trust. We are talking about a cliff dive in the summer of 2022.
Yeah, the numbers present a really stark picture. In the summer of 2022, Gallup measured the public approval rating of the court, and it fell to 40%.
Wait, 40%?
40%, and according to the source, that is the lowest number in Gallup's recorded history for the institution.
Wow.
And it gets worse because a companion survey conducted around the same time revealed something even more foundational. Only 25% of Americans had, quote, a great deal or quite a lot of confidence in the institution.
So just 1 in 4 people.
Right. And Pew Research and Quinnipiac, they found the exact same signal through the noise. We are talking about a drop of over 20 points in just 2 years.
That is a massive shift. So basically, a quarter of the country has strong confidence in an institution that literally dictates the boundaries of their daily lives. But, why does that specific metric, public confidence, why does that matter so much for a court? If a senator has a 25% approval rating, they might lose an election, right? But the Senate still functions. A court isn't running for re-election.
That's a great question. And to understand why it matters so much, the text brings us all the way back to Alexander Hamilton.
Oh, going back to the founders.
Yeah, specifically Federalist number 78. Hamilton famously called the judiciary the least dangerous branch.
Right.
And his reasoning was entirely mechanical. Think about it. The legislative branch, they control the purse, right? They can levy taxes. They can spend money.
Yep, the power of the purse.
And the executive branch controls the sword. They command the military and federal law enforcement. But the highest court has neither. They literally have no money, and they have no army.
All they have is their judgment.
Exactly. All they have is judgment.
Meaning their entire power rests entirely on the public's willingness to listen to them. Their only currency is legitimacy.
You hit the nail on the head. If that trust goes bankrupt, their rulings are they're just ink on paper.
Right. If the public, and the other branches of government for that matter, if they stop believing the court is a legitimate arbiter of the law, the whole mechanism of compliance just breaks down.
It completely fractures. And to understand how we got to the very edge of that bankruptcy, the material pulls us back to the literal biological architecture of the court itself.
Biological architecture.
Yeah, it starts with an 18th century reality that the founders simply did not and could not anticipate.
Okay, wait. Before we get to biology and medicine, let's talk about the design for a second.
Yeah.
Didn't the founders intentionally design this institution to be immune from public opinion?
That's what we're always taught, yeah.
Right. I always thought, lifetime tenure was this deliberate feature so judges wouldn't have to bow to political pressure.
It is a super common myth. but the text forces us to look at the actual literal wording of Article 3 of the Constitution.
Okay, what does it say?
It actually does not say justices have lifetime tenure. It says judges shall hold their offices, quote, during good behavior.
Good behavior. Not for life.
Right. That specific phrasing was borrowed directly from 17th century English law. It was designed as a shield against royal or executive pressure.
Ah, I see. So they just wanted to ensure a president couldn't just, fire a judge for handing down a politically inconvenient ruling.
Exactly. But they absolutely didn't anticipate modern medicine. The demographic shift outlined in the sources here is just wild.
Yeah, lay out those numbers because this blew my mind.
So in 1788, when the Constitution was ratified, the average life expectancy at birth in the United States was under 40 years old.
Under 40.
Under 40. So even if someone was appointed in their early 50s, they might serve, maybe 10 or 15 years? The data shows the average early tenure was about 8 years.
Wow, just 8 years. And then you fast forward to the modern era.
Yeah, justices are definitely not serving 8 years anymore. William O. Douglas served 36 years. John Paul Stevens served 34 years.
That is a long time to hold that kind of power.
William Rehnquist served 33. And Clarence Thomas is currently on track to become the longest-serving judge in American history.
We are talking about individuals shaping the supreme law of the land for 3 or 4 decades.
Decades, yeah.
It's kind of exasperating when you think about the sheer scale of it. I mean, a president who might have even lost the popular vote, serving a single 4-year term, can install a 48-year-old justice who will literally outlive the political careers of the senators who confirmed them.
Yep.
They will be handing down rulings that govern the lives of citizens who haven't even been born yet.
And the text points out that this alters the entire incentive structure of our political system. Because they serve for generations now, it transforms every single vacancy into this existential, generation-defining political war.
Right. The stakes are just so incredibly high that the old, bipartisan confirmation process, it just couldn't survive the pressure.
No, it buckled completely.
Because if you look at the historical timeline provided in our source today, confirmations actually used to be fairly rapid and remarkably bipartisan.
They really were.
Look at Louis Brandeis in 1916. The guy was wildly controversial for his time. He was a fierce progressive, the first Jewish justice nominated, and yet he was confirmed after just 4 months with a pretty solid bipartisan vote. The system held.
But the text pinpoints a very specific watershed moment where that old system fractured for good, 1987.
The Bork nomination.
Exactly, the nomination of Robert Bork by President Ronald Reagan. According to the source, this is where the modern ideological sorting machine was truly born.
Right.
For the first time, a nominee's specific, overarching judicial philosophy became the explicit terrain for full-scale partisan combat.
And Bork was ultimately rejected, 42 to 58?
Yep. Which the text notes remains the largest margin of defeat in history.
Yeah.
And that battle fundamentally rewrote the playbook for how you get a human being onto the highest bench.
It created what the author refers to as the Ginsburg rules, right?
Yes, exactly.
Which is just, it's that frustrating, brilliant piece of strategic opacity we see at literally every confirmation hearing now.
The performance art.
Yes. The nominee sits before the Senate Judiciary Committee. They project immense gravitas. They speak beautifully about the majesty of the law in the abstract.
And they absolutely refuse to say anything of substance about how they would actually rule on specific controversial cases.
It is pure performance art.
It's performance art designed specifically to minimize political cost. But here is the critical pivot the source highlights. While the nominees became completely opaque to the public and the Senate,
the vetting process behind the scenes became surgically precise.
Exactly. After the Bork defeat, conservative legal scholars realized that Republican presidents had a bad habit of appointing what they called surprise justices.
Like Earl Warren or David Souter.
Right. Nominated by Republicans, but they ended up drifting left and voting with the liberal wing on major constitutional questions over time.
So the pipeline had to be formalized to eliminate that ideological uncertainty.
That was the goal. The text details the rise of the Federalist Society, founded in 1982, which essentially became the vetting clearinghouse. The goal was simply no more surprises.
And the result of that pipeline is exactly where we are today. For the first time in American history, the court is perfectly, seamlessly, ideologically sorted by the party of the appointing president.
Perfect sorting.
The conservative bloc votes one way on major questions, the liberal minority votes the other. You can predict case outcomes with startling reliability based entirely on which president appointed the majority.
And just to step back for a second and provide some global perspective, the source pulls back the lens to show how structurally bizarre the United States is compared to the rest of the democratic world in this regard.
Oh, we are a massive outlier.
A huge outlier. If you look at the German Federal Constitutional Court, which the text notes is widely considered one of the most successful and respected in the world, they limit their judges to a single non-renewable 12-year term.
Just 12 years.
Right. And Canada requires mandatory retirement at age 75. The UK requires retirement at 75 as well.
So these global systems intentionally prevent the constitutional interpretation of an entire nation from being captured by a single political moment for 40 years.
Exactly. They engineer the system to avoid exactly what we are dealing with.
But because we don't have those limits, because the desperation to fill these lifelong seats is so intense, the unwritten rules of the United States Senate finally snapped.
They absolutely snap.
And this brings us perfectly to the subtitle of our source material today: A Study in Institutional Failure, Political Capture, and the Future of the Judiciary. Let's walk through the exact timeline of the Garland rupture in 2016.
Yeah, this is where the theory of norms gets severely tested. Let's set the scene. February 13th, 2016, Justice Antonin Scalia dies unexpectedly.
And he was the intellectual anchor of the conservative wing.
Right, so his death didn't just open a single seat. It meant the entire ideological balance of the institution could shift to a liberal majority for the first time in a generation.
Because a Democratic president, Barack Obama, was in office at the time.
Exactly. And the response from the Senate wasn't a debate over qualifications or who the nominee might be. It was an instantaneous, absolute blockade.
Literally within hours.
Within hours of Scalia's death, Senate Majority Leader Mitch McConnell announced that the Senate would not even hold a hearing for anyone Obama nominated.
And the justification they used was this invented norm, right?
Yes. The idea that because it was a presidential election year, the public should vote first, and the seat should remain vacant until a new president was installed.
The source is deeply analytical about this specific claim. It was entirely unprecedented. There was no constitutional text requiring it, no Senate rule authorizing it, and absolutely no historical precedent for holding a seat open for nearly a year just because an election was approaching. Presidents had made election year appointments throughout American history.
Right. The text argues it was a rule invented in the moment, out of thin air, to prevent a specific political outcome.
So President Obama goes ahead and nominates Merrick Garland anyway. And by all traditional metrics, Garland is the definition of a moderate, consensus, highly respected appellate judge.
Top Republicans had actually praised him on the record previously.
But he hits a brick wall. For 293 days, the Senate simply refused to hold a hearing.
It remains the longest vacancy driven by Senate inaction in American history. The clock runs out, a new president takes office, and the seat eventually goes to Neil Gorsuch.
But the text argues that to understand the true destruction of that norm, you have to look at the sequel.
Oh, the sequel is where it all falls apart. September 18, 2020, Justice Ruth Bader Ginsburg passes away.
Just 46 days before the presidential election.
46 days.
Millions of Americans were literally already in line casting early ballots. If the hard and fast rule established in 2016 was that you cannot fill a seat in an election year because the voters need to speak,
Right.
then surely you can't fill a seat weeks before the election, right? I mean, that's just logical.
But according to the historical record laid out in the material, the circumstances were constitutionally identical, but the result was the exact opposite.
The invented norm of 2016 just vanished.
Vanished into thin air. The Senate moved with unprecedented speed and confirmed Amy Coney Barrett in a matter of weeks, swearing her in just 8 days before the 2020 election.
And this is where the text gets deeply philosophical, and I think it's crucial for you listening that we don't just dismiss this as standard political hypocrisy.
Right, hypocrisy is cheap.
Exactly. Politicians being hypocritical is not breaking news. But the author defines this specific sequence of events as an epistemological norm destruction.
Think about what a norm actually is. It's an unwritten rule. People only follow it because breaking it carries a severe reputational or political penalty.
But if a norm can be broken without penalty, and in fact rewarded with a lifelong generation-defining seat on the highest bench, then the norm ceases to exist entirely.
It vaporizes. All that remains is naked power.
Naked power. And once that vaporizes, it triggers severe retaliatory consequences across the entire system. You can see the direct result of this norm destruction in 2022.
Right, when Justice Stephen Breyer decided to retire. The analysis indicates his retirement was strategically timed to ensure a Democratic replacement was confirmed before the midterm elections could potentially flip control of the Senate.
The calculation for stepping down is no longer about judicial readiness or health, or even a desire to retire.
No, it is purely, explicitly about maximizing partisan advantage, because the institutional guardrails have been completely stripped away.
Okay, so if the process of getting onto the bench has devolved into a bare-knuckles, rules-free fight, it forces a really uncomfortable question. What rules govern these people once they are actually seated holding this immense power?
And the answer, according to the source, for a shockingly long time, was almost none.
Let's step into the ethics void.
The text centers this part of the crisis on the revelations that began dropping in April 2023. ProPublica released an explosive investigative report focused on Justice Clarence Thomas and a billionaire real estate developer and conservative political donor named Harlan Crow.
And we have to be clear here. We are not talking about a judge letting a friend pick up the check at a nice steakhouse.
No, the scale is massive.
The source walks through a staggering, decades-long list of undisclosed gifts. Private jet travel valued in the hundreds of thousands of dollars, voyages to Indonesia on a super yacht,
Private school tuition payments for Justice Thomas's great-nephew.
and Harlan Crow even purchased real estate in Georgia directly from Justice Thomas's mother, for a price that the text notes had no market comparables.
And then allowed her to continue living in the home rent-free while he paid for renovations. We are looking at well over $1 million in undisclosed financial value.
Over $1 million.
While the text analyzes this as a profound individual ethical lapse, it emphasizes that it exposed a massive systemic structural anomaly in the American judiciary.
What do you mean by anomaly?
Well, at the time these reports were published, the United States Supreme Court was the only federal court in the entire country explicitly exempt from the binding code of conduct for United States judges.
The only one.
The only one. Every single district court judge, every appellate judge across the country has to follow incredibly strict binding rules on financial disclosures, gifts, and the appearance of impropriety.
But the 9 individuals wielding the absolute most power were completely exempt from that code.
Exactly.
But wait, didn't the public backlash force them to finally adopt a code? I vaguely remember reading they passed something in November of 2023.
They did. They adopted a 9-page code of conduct. But the author highlights a massive, glaring catch. It has absolutely zero enforcement mechanisms.
Zero.
Zero. There is no independent authority to investigate a potential violation. There is no formal process for determining if a violation actually occurred, and there is no sanction available if one did. As the ethics scholars quoted in the text point out, a code of conduct without an enforcement mechanism isn't a rule book. It's just a public relations document.
Which bleeds directly into this other structural crisis the author calls the unreviewable recusal.
This is a huge point.
Right, because if I go to a local court and the judge presiding over my case has a massive undisclosed financial tie to the person I'm suing, I can file a motion demanding that judge recuse themselves.
Right.
And if they refuse, a higher court can review that decision and literally force them off the case.
But on the highest bench, there is no higher court. And critically, they have decided that no peer review mechanism exists either.
Meaning?
A justice's decision to recuse or not recuse is entirely 100% unilateral. No other justice, not even the Chief Justice, can force a colleague to step aside from a case, no matter how blatant the conflict of interest might appear to the public.
And the text provides a chillingly specific example of how this unilateral system fails in practice. We have to look at the text messages involving Ginny Thomas, Justice Thomas's wife.
Right, the 2020 election texts.
According to the investigative records cited in the source, she was actively texting the White House Chief of Staff, Mark Meadows, in the days immediately following the 2020 election. She was explicitly urging him to pursue efforts to overturn the election results.
And fast forward a bit. A case arrives at the Supreme Court regarding the release of White House communications to the January 6th Congressional Investigative Committee, communications that would include those very types of texts.
And Justice Thomas does not recuse himself.
He does not. In fact, he participates in the case and acts as the sole dissenting vote in an 8-to-1 order that ultimately required the release of those documents.
Unbelievable.
The unilateral recusal system relies entirely on a justice's own internal compass, and the source argues this represents a catastrophic governance failure.
And to be absolutely fair to the text, it notes this isn't an isolated problem pinned on a single justice. The structural void spans ideological lines.
It's systemic.
Right. The material cites reports involving Justice Samuel Alito taking an undisclosed luxury fishing trip to Alaska with a billionaire hedge fund manager who repeatedly had interests before the court.
It also mentions Justice Neil Gorsuch selling property to the CEO of a major law firm that frequently argues cases before the court just days after his confirmation.
And it notes Justice Sonia Sotomayor's staff reportedly pushing public institutions to purchase large quantities of her books in conjunction with speaking engagements.
The author is mapping out a systemic problem. It is a structural void where ethical corners are routinely cut simply because there are no guardrails to prevent it.
Okay, so an ethics void severely damages public trust, without question. But according to the analytical framework of the text, it escalates from a structural problem into a massive, acute crisis when the actual decisions being handed down systematically conflict with the will of the Democratic supermajority.
And this is a critical pivot in our deep dive today. We are going to walk through what the author calls the doctrinal record.
And just a quick note for you listening, as we go through these cases, we are acting strictly as reporters of the source material. We're looking exclusively at the polling data and the judicial outcomes provided in the text, examining how the machinery operates. We are not taking sides.
Exactly. We're just looking at the data. Let's start with the seismic shift in 2022, Dobbs v. Jackson.
The Dobbs decision is analyzed in the source as a generational doctrinal reversal.
It overruled Roe v. Wade, thereby eliminating the federal constitutional right to abortion and returning the authority to regulate or ban the procedure entirely to the individual states.
And the majority opinion, authored by Justice Alito, fundamentally rooted its logic in the idea that the right to an abortion was not deeply rooted in the nation's history or traditions.
But when you look at the raw polling data the author pulled for this section, the disconnect between the bench and the public is incredibly stark.
The data shows that between 60 and 66% of Americans opposed overturning Roe.
But the text argues that what really sent shockwaves through the public consciousness wasn't just the reversal itself, but Justice Clarence Thomas's concurring opinion.
Yeah, break that concurrence down for us.
The text highlights that in his concurrence, Justice Thomas explicitly called for the court to reconsider other landmark cases using this exact same legal framework. He specifically cited the cases that currently protect the rights to obtain contraception and the right to same-sex marriage.
And the source points out that those specific rights enjoy even higher supermajority support among the public.
Much higher.
The polling data maps support for contraception access and same-sex marriage upwards of 70 to 80%. So you have a doctrinal theory being floated from the highest bench that directly threatens rights supported by 4/5 of the country.
The text then moves to the Brune decision, handed down the very same year, regarding the Second Amendment and gun regulation.
Right. In this case, the court struck down a long-standing New York concealed carry law. But more importantly for the future of the law, it established a brand new historical test for evaluating gun regulations.
And this test is crucial to understand. Under this new standard, modern gun laws are only considered constitutional if the government can prove there is a distinct historical analog, basically.
Right.
A similar law that existed during the founding era, around 1791, or during Reconstruction, around 1868.
So they have to find a law from hundreds of years ago to justify a modern regulation.
Exactly. And the author contrasts that rigid 1791 standard with modern demographic polling provided in the text.
What do the numbers say?
The data shows 80 to 90% public support for universal background checks and 60 to 70% support for red flag laws.
Wow.
By requiring a historical analog from the 18th century, the court essentially insulates the issue from contemporary Democratic majorities.
Right. It doesn't matter if 90% of the public wants a new safety regulation today. If they didn't have a version of it when muskets were the primary weapon, it is highly vulnerable to being struck down.
The doctrinal record also dives deep into federal agency power, specifically looking at West Virginia v. EPA and the Loper-Bright decision.
Ah, right, administrative law. In these rulings, the court fully established what they call the major questions doctrine and ended a massive 40-year-old legal precedent known as Chevron deference.
Let's unpack Chevron deference because it sounds like impenetrable legal jargon, but its impact on daily life is actually massive.
Yeah, please explain that one.
For 40 years, the operating rule was this. If a law passed by Congress was vaguely worded or ambiguous, the courts would defer to the expert administrative agencies, like the Environmental Protection Agency or the Food and Drug Administration, to interpret the technical details of how to enforce it.
But the Loper-Bright decision effectively ended that automatic deference.
Completely ended it.
So practically speaking, let's say Congress passes a broad law saying the water supply must be kept safe from toxic chemicals. And then a few years later, a brand new, highly complex synthetic chemical is invented.
All right.
Previously, under Chevron deference, a team of PhD scientists and toxicologists at the EPA would analyze it and decide if it falls under the ban. The courts would defer to their scientific expertise.
But now, without that deference, a federal judge with a law degree, who might not know the first thing about advanced molecular chemistry, gets to make the final call on whether that chemical is regulated.
That is a massive shift in how the government operates. It transfers immense, sweeping power away from subject matter experts and executive agencies and hands it directly to generalist judges to decide what the law means.
And the practical effect, according to the source's analysis, is that it severely limits the ability of the federal government to take sweeping action on complex, modern issues like climate change.
Which again brings us back to the polling. Even though the data in the text shows 55 to 70% public support for government intervention on climate change, the court's new rulings require explicit, hyper-specific authorization from Congress for any major regulatory action.
And we all know that passing hyper-specific, forward-looking legislation through a frequently deadlocked Congress is, well, it's nearly impossible.
Finally, the source highlights a major ruling from 2024, Trump v. United States. In this decision, the court ruled that former presidents enjoy substantial, and in some cases absolute, immunity from criminal prosecution for official acts taken while in office.
The ruling created a complex framework distinguishing between core constitutional powers, official acts, and unofficial acts.
And once again, referencing the source data, the public sentiment was entirely misaligned with the ruling.
What were the numbers there?
Roughly two-thirds of Americans surveyed believed a former president should be subject to standard criminal prosecution for illegal acts, while only about a quarter supported the kind of sweeping immunity shield the court introduced.
The pattern the author outlines across all these cases is unmistakable. Major, society-altering decisions systematically diverging from supermajority public opinion.
And the text makes a vital point here. These decisions aren't happening in a vacuum. And they aren't historical accidents either.
Right. The source material maps out how the court was deliberately, methodically turned into the ultimate prize in America's culture wars.
The text maps out this incredible long-horizon strategy. Conservative legal movements, stretching back decades, felt they simply could not roll back the massive civil rights and regulatory expansions of the Warren Court through the normal legislative process.
They couldn't win those specific fights in Congress.
Exactly. So they opted for a multi-decade strategy to achieve those exact same policy rollbacks through judicial interpretation instead. They built the Federalist Society pipeline, they played hardball with the Garland seat, and they captured the bench.
And you see the visceral, real-world fallout of placing the court at the absolute bleeding edge of the culture war. The text points to the unprecedented leak of the Dobbs draft opinion in May 2022.
That leak shattered the internal trust of the institution.
It really did. It led to massive, sustained protests. An armed man was arrested near Justice Brett Kavanaugh's home. And the ultimate response was the physical fortification of the Supreme Court building itself.
The author describes it so vividly. A building that was originally designed to be an open, accessible civic space, literally the temple of American law, was suddenly transformed into a security objective surrounded by unscalable, non-climbable fencing and concrete barriers.
It is a stark, physical manifestation of the breakdown in public trust. The fortress mentality takes over when legitimacy fails.
And the text also asks us to look at international parallels to truly understand the stakes of what we're watching.
Yeah, because when democratic stress happens globally, the judiciary is almost always ground zero.
The source points to Hungary, where Viktor Orban systematically altered retirement ages and packed the constitutional courts with loyalists to solidify his power.
It also points to recent massive protests in Israel over attempts to gut judicial review and similar democratic backsliding in Poland.
It shows that turning a high court into a blunt instrument of partisan policy, rather than maintaining it as an independent check on power, has real, measurable consequences for individual rights and democratic norms all over the globe.
The playbook is remarkably similar wherever you look.
Now, a natural pushback to all this data is to look at history. I'm sure you, listening right now, might be thinking, hold on, hasn't the Supreme Court always been intensely political? Hasn't it always made people angry?
And the source material agrees completely. Yes, it has always been a political flashpoint. But it argues forcefully that this specific moment is fundamentally different.
Let's run through the history the text provides, because the court has been infuriating people since the ink on the Constitution dried.
Oh, absolutely.
You have the Marshall Court in the early 1800s aggressively asserting federal supremacy over the states. That made President Andrew Jackson so furious he supposedly dared the Chief Justice to enforce his own ruling.
Then you have the Tyranny Court in 1857 delivering the Dred Scott decision.
Arguably the most disastrous, morally bankrupt ruling in American history, deciding enslaved people couldn't be citizens, which directly accelerated the path to the Civil War.
You also have the Lochner era in the early 20th century. This was a period where a highly conservative court kept striking down popular progressive labor laws, like minimum wage standards, maximum hour laws, and child labor restrictions.
Claiming they violated the freedom of contract.
Right. And that obstructionism is what ultimately led Franklin D. Roosevelt to threaten to pack the court in 1937 to save his New Deal.
And then, of course, there was the Warren Court, spanning from 1953 to 1969. The text points to this era as a massive piece of the modern puzzle.
It was a huge turning point.
The Warren Court handed down rulings like Brown v. Board of Education desegregating schools, Miranda v. Arizona establishing rights for criminal suspects, and Gideon v. Wainwright guaranteeing the right to an attorney. It was a massive, unprecedented expansion of civil liberties.
And it sparked a massive immediate backlash. Impeach Earl Warren billboards popped up along highways across the country.
So the conservative legal movement we see operating today was explicitly built as a generational counter-movement to the perceived overreach of the Warren Court.
Exactly. So historical controversy is entirely normal. But the source material synthesizes exactly why today is a different beast entirely.
So what is it? If anger is normal, what makes this a unique crisis?
It is the unprecedented combination of factors. The author calls it the perfect storm.
Okay, let's hear the storm.
It is the biological reality of lifetime tenure in an era of expended life expectancy, combined with perfect ideological sorting by political party, combined with the raw procedural norm destruction of the Garland and Barrett seats, combined with massive structural ethics failures and a lack of transparency.
That specific matrix of failures has never existed simultaneously before in American history.
Never.
So if the bench is broken, if matrix has failed, what are the tools actually available to fix it? The text elevates 4 distinct proposals. These used to be things only debated in obscure academic law review journals, but now they are entering serious legislative debate.
Let's look at the reform options, starting with what the author considers the moderate path. Term limits.
Okay, how does that work?
The most common and widely supported proposal is establishing an 18-year staggered term for justices. The math is elegant. A president gets to appoint exactly 1 justice every 2 years during their term.
So every presidential term yields 2 appointments.
Exactly. Lowering the temperature and making the ideological balance of the court a direct, predictable reflection of recent presidential election.
But wait, how do you actually do that? You just told me earlier that Article 3 says they serve during good behavior. Doesn't changing that require a constitutional amendment?
That is definitely the hurdle people point out.
Because getting 2/3 of Congress and 3/4 of the states to agree on amending the Constitution right now feels, well, completely impossible.
It is impossible, but the text details a brilliant constitutional workaround that scholars have developed. The Constitution says justices serve during good behavior and therefore keep their lifetime salary and title. But it does not strictly say they must spend their entire life actively voting on the Supreme Court. The proposal suggests a statute transitioning justices to what is called senior status after 18 years.
Ah, I see. So they'd still technically be federal judges. They keep their salary, they keep their lifetime tenure, satisfying Article 3, but they would rotate off active duty on the high court.
Right, perhaps hearing cases on lower appellate courts instead.
That is incredibly logical. It makes the stakes of each vacancy so much lower. But if that's the moderate option, let's talk about the radical one, court expansion, often called court packing.
The source outlines the scope of proposal. The Supreme Court Code of Ethics, Recusal, and Transparency Act's more aggressive cousin. This is often tied to expanding the court to 13 justices.
Why 13?
The logic here is structural, expanding the bench to mirror the 13 federal circuit courts that currently exist. And constitutionally, this is totally legal. The Constitution does not set the number of justices at 9.
Congress sets the size of the court by standard legislation.
Mhm.
And in fact, the size of the court has been changed 6 times in American history.
But the text points out a massive, glaring risk here, the tit-for-tat problem.
Right. If one political party uses a slim majority to add 4 justices today to recapture the ideological balance, what mathematically stops the other party from adding 4 more the very next time they hold power?
Nothing stops them. You could easily end up with a 30-person Supreme Court in a decade. It would just look like a secondary, unelected branch of the legislature.
And history is a warning here. FDR tried to expand the court in 1937 and failed spectacularly because even his own party thought it was a gross abuse of executive power.
Which leads us to a lesser-known but utterly fascinating power detailed in the text, jurisdiction stripping.
Jurisdiction stripping.
Yeah. If you look at Article 3, Section 2 of the Constitution, there is a provision known as the Exceptions Clause. It explicitly gives Congress the power to limit what kinds of appellate cases the Supreme Court is actually allowed to hear.
Think of it less like taking the steering wheel away from the driver and more like Congress changing the locks on the courthouse doors.
I like that analogy.
The court still exists, the 9 justices are still sitting at their heavy mahogany desks, but Congress passes a law saying cases regarding environmental regulations literally do not have a key to get into this building. You have no jurisdiction to hear them.
Exactly. Congress controls the docket. The source cites a historical case from after the Civil War, ex parte McCardle. Congress successfully stripped the court's jurisdiction to hear a specific type of appeal, and the Supreme Court upheld it, admitting they had no power to proceed.
But the text issues a severe warning about this tool. It is incredibly dangerous.
Extremely dangerous.
If it is normalized, you could have future Congresses routinely stripping the court of the ability to hear First Amendment cases or civil rights cases, essentially immunizing unconstitutional laws from judicial review altogether.
And finally, the fourth reform avenue, ethics reform. The source suggests this is structurally the easiest to pass.
It would involve passing a law requiring external enforcement mechanisms, mandatory and transparent financial disclosures, and clear, reviewable recusal standards where a panel of other judges could force a conflicted justice off a case.
It is the most politically viable, but the author notes it is also the most limited. It stops the bleeding of public trust regarding financial conflicts and super yacht vacations, sure.
But it does absolutely nothing to fix the demographic realities, the ideological sorting, or the doctrinal divergence from the supermajority.
Right. Before we can even debate pulling any of these reform levers, the text forces us to step all the way back. It asks the deepest, most existential question of the entire deep dive.
What actually makes a court legitimate in a democracy in the first place?
The source points to Alexander Buckel's famous theory termed the countermajoritarian difficulty. Beckel pointed out that inherently, by its very nature, a Supreme Court is an anti-democratic institution.
Because you have 9 unelected people appointed for life who possess the power to strike down laws passed by the elected representatives of hundreds of millions of people.
Exactly. So how is that massive override power allowed in a system that prides itself on being a democracy?
Bickel argued it is only acceptable, and the institution only survives, if the process of the court is viewed by the public as fundamentally fair, consistent, and bound by principle rather than politics.
The text refers to this concept as legitimacy-based compliance.
Right. We don't obey court orders because the Supreme Court has a private army ready to arrest us if we don't. We obey because of a shared, collective, almost invisible belief in the court's inherent authority.
The process must be deeply respected, even if you absolutely hate the outcome of a specific case.
And the endgame that the author warns about, if that shared belief evaporates, is truly terrifying for the stability of the nation.
When procedural legitimacy erodes completely, when the public looks at the bench and just sees politicians wearing black robes appointed through broken, unwritten rules, taking secret, undisclosed gifts, and ruling against the vast majority of the country, the reservoir of compliance dries up.
It starts subtly. State governments might just start finding creative ways to ignore federal court orders.
The executive branch might drag its feet on enforcing rulings they disagree with.
And when that happens, the entire constitutional framework, the delicate balance of powers that has held the country together for centuries, begins to fracture. Which leaves us with a final, profound thought to mull over today.
What is that?
If the Supreme Court's immense power over our lives relies entirely on our collective, shared belief in its fundamental fairness, what happens the morning after a majority of Americans simply decide to stop believing?
Wow. And it is crucial to note that this entire fascinating conversation today is derived entirely from the first book of the incredible 30-volume series, To Preserve, Protect, and Defend the Soul of America.
Exactly. Specifically, we've been diving into the book titled Volume 1, America's Healthcare Crisis and Broken Public Institutions, authored by Sue B. Howell.
And the great news is this book is now available in all Amazon bookstores across the world.
We highly encourage you to go check out the book, buy a copy, dive into these incredible sources yourself, and please leave comments and feedback. We'd love to hear what you think of it. Thank you for joining us on this deep dive. Stay curious, stay informed, and we'll see you next time.